I thank you for being here. Up next, I am going to turn it over to Lauren with the Education Rights Counsel to really talk about the history and the lawsuit. And I'm just going to let Lauren do her thing. So,
Hello, everyone. I am going to share my screen real quick. So my name is Lauren Micek Vargas, and I am the CEO of Education Rights Counsel. We are a Nebraska-based nonprofit that ensures that all children can stay in school and thrive. And I also want to introduce my counterpart, Elizabeth Eynon-Kokrda, who is also on here. She is the co-founder with me to Education Rights Counsel. Just a quick background, I am an attorney, but first and foremost, I am a teacher. I started as a special education teacher and then became an attorney advocating on behalf of students' rights. And Elizabeth has been in the education law arena for over 20 years, advocating on behalf of districts initially and now families, which is why we strongly believe in Section 504. Today, we're going to talk about what is at stake in the current lawsuit that is happening. Elizabeth and I will jump back and forth. And if you have questions, please put them into the chat and we will try to address them as much as possible given the time that we have. And Wendy, if you want to just shout them out to us, that's also fine as well. Let me tell you just a little bit about Section 504. So give me a hand raise on your Zoom because we're not in person. If you know what Section 504 is, etc. Section 504 is a civil rights law. It arose out of litigation. Thank you, Roger. Woo woo. Thank you for using that. Yeah, thank you. It is a civil rights law. It arose out of litigation coming and stemming from a civil rights movement. And so before Section 504, which then got passed in 1973, the responsibility or for the consequence really of disability rested on the shoulders of individuals who had disabilities. It rested on their shoulders to find out what that accommodation should be. However, Section 504 said, and you can read it here, that no otherwise qualified handicapped individual in the United States shall solely on the basis of his handicap be excluded from participation, be denied benefits, or subjected to discrimination under any program or activity, receiving federal financial assistance. And what that means is this comes under the spending clause statute. The federal government says to states, hey, do you want our money? States say, yes, we want your money. This is very, very simplistic, by the way. So for any attorneys on here, don't judge me. But as a state will say is, I want that money. And then the federal government says, okay, you can have this money if you follow certain laws. And one of those laws is Section 504, which does not allow for the discrimination of individuals with disabilities and operates as a social model of disability, so which focuses instead on an individual's not on an individual's impairment, but on ways in which their surroundings can better accommodate the individual's needs. It took about 4 years to pass. It required an entire movement of sit-ins, marches, activism. I would strongly recommend you attending some of these book clubs and movies that Wendy's discussed and will be publicizing later to learn more. So what does Section 504 actually do? It is a series of regulations that covers all federally funded programs. This is something that covers doctors, hospitals that take Medicaid or Medicare, governmental entities such as child welfare systems, clinical research, etc., and school districts. Section 504, Wendy mentioned some of those examples, but it's why we have ASL interpreters today as well. Accessible college campuses, service and assistance animals, headphones, text to speech, speech to text, name something, glasses, etc. Being able to sit in front of a classroom, having interpreter services in hospitals, etc. All these different things, anything you can think of, fidget spinners. These are all accommodations that are protected under Section 504. And I do want to mention if you were ever a woman and pregnant, you also were protected under Section 504 for that period of time. So let's talk about what those updates looked like. In July of 2024, so just a year ago, there were updates that were created by the federal government, and this was under the previous administration. And in those regulations, it focused on expressly prohibiting medical decisions based on biases and stereotypes or the use of value assessments, quote unquote, requiring accessible medical equipment, websites, mobile apps, defining integration and segregation, and explicitly applying the regulations to residential and day and educational services, and support effective communication with primary consideration. This also discussed aligning service animals with ADA regulations. Elizabeth, I'm going to also have you just jump in here real quick for me. And can you just talk about why it's a series of regulations rather than statutes?
Sure. So the statute, any statute, if you're a non-lawyer, basically gives a framework. It's an outline. And before it can be implemented, you need all the interstices, the regulations. So nearly every statute gives authority to a regulatory body or bodies to say, how is this going to work? This particular regulation was issued by DHHS. So it's focusing on medical more than education. The Department of Education, if we have one, also has regulations that impact how it impacts you in school. And so the way this lawsuit that Lauren is going to talk about more is coming to the fore is because when these regulations came out, they included one particular phrase, and it's actually not even in the regulation, in the what's called the preamble. Every time there's a regulation that's a federal regulation, the first thing they do is they take comment and they give procedures to share those comments with the public. Everybody can ask questions. And then before they issue a final regulation, which is this one effective in January 8th, they answer those questions and they say, Elizabeth wrote in and said, you need to do this, but we're declining to do it. And here's why. One of the questions that came in was, is gender dysphoria now a disability? And what these regulations said in the preamble is, well, it may be, depending on the facts. It's not even in the regulation. But the regulations tell everybody what they need to do. I only bring that up because that's where this whole big problem allegedly came out of, even though we're not really buying that.
So, going on with what Elizabeth was saying, what happened is because of what was listed in the preamble, in September of 2024, 17 attorneys general filed a lawsuit in Texas challenging those regulations as unconstitutional. They specifically said that it was due to gender dysphoria being named as part of the preamble as a potential protection. Right? Again, it wasn't part of the regulations, as Elizabeth mentioned. It was part of the preamble as a potential maybe. But what really was at the crux of the lawsuit was that it focused on specifically the constitutionality of Section 504 itself. So the top four things: access to service and community instead of institutions. They also challenged protections against discrimination in medical treatment, requirements for accessible medical equipment, and also concerning effective communications. But you should know, hidden inside of this lawsuit, I think it was page 32 or 37 or something. I can't remember exactly at this moment. But inside this lawsuit, they specifically asked the Fifth Circuit to find Section 504 unconstitutional because they suggest that it violates the spending clause because it's not as explicit or clear of notice of their obligations when accepting those federal funds. They also say that the law is unfair and coercive by compelling states to comply with federal standards without getting specific approval from Congress, despite the fact that Section 504 in and of itself was approved by Congress. Now, one thing that we should mention is that one of those 17 states was Nebraska, which I think many of you are from, and also Iowa, which is why we're discussing that today.
Hey,
So
Lauren,
yeah, go for it.
can I just put one?
Yeah.
You know how earlier you said it was the spending clause, it's a spending clause, and that's why they're saying it's unconstitutional. I want everybody on this to think about this. As Lauren said, this particular law says you can't discriminate on the basis of disability because you've accepted our money. Think about every other law that's out there that says if you accept funds, you have to do X. If this were to go through, Lauren will talk more about this, but if it were ever found that it violates the spending clause because you are basically saying, yes, I'll take this, and then a regulation is adjusted, and then they say, oh no, that you can never adjust a reg. Imagine the domino effect across the United States. Okay, go, Lauren. Sorry.
And jumping off of what Elizabeth said, this would have detrimental effects not just on individuals with disabilities, but on all civil rights laws that are applied through the spending clause. So here's the current status of the litigation. In April of 2025, the plaintiffs told the court through what's called a joint status report that they had no intention to seek relief. In regards to Section 504. So even though they asked for it in the lawsuit, they now had no intention to seek that relief, right? Or demand the court to block HHS from enforcing Section 504. But the attorneys general have not actually amended their complaint. Now, I know that this is nuanced and it gets all legalese, and I'm not trying to make it confusing, but what they have the ability to do is to say, yeah, you're right. We can either amend it and say Section 504 should still stand. It should still be the law of the land. They have not done that. They could also withdraw from the entire lawsuit. They also have not done that. As of on July 29th, we will find out what is going to happen. But there was another joint report, and currently it's on pause. The lawsuit is stayed. Elizabeth, do you want to mention anything else that I'm missing there? Oh, I think you're muted.
Well, yeah, the second bullet. So what happened is plaintiffs asked to stay this, and then they gave a status report that said, oh, never mind, we don't really want that, but didn't amend, just like Lauren said. Then DHHS, under the current administration, came out and said, hey, that gender dysphoria stuff, it's in the preamble. It is not part of the law. So that also should moot part of the complaint. And guess what? They haven't amended their complaint about that either. So there's the whole rationale for the complaint has disappeared, and they haven't taken out the fundamental requests.
So because of that, these significant challenges remain. At risk, specifically through this lawsuit, is the right to receive services in community instead of institutions, a ban on disability discrimination and medical treatment decisions, accessible medical equipment, websites, kiosks, etc., reasonable accommodations, and effective communications. But what is at risk at general for any individual who works with or is a person with a disability is the entire way that our society looks at individuals with disabilities. If plaintiffs prevail on remaining aspects of the litigation, it will, as Elizabeth mentioned, be a domino effect. It will start to impact all of civil rights. Regardless of which administration it is okay to enforce the disabled to go into institutions if this tumbles, to not have access to medical services, to not make medical decisions based off of disability, etc. It will impact education, employment, governmental offices, services. It really runs the gamut in regards to who it can impact. For that reason, what we are asking today, and what everybody should know, is that becoming or being an individual with a disability can happen to anyone. It can happen in any moment. We are witnessing a coordinated effort to weaken protections for people with disabilities, to weaken and attack Section 504. It was born out of protest and out of knowledge that individuals with disabilities should be part of society. Therefore, it must be defended with the same urgency and action, not just by individuals with disabilities. It shouldn't be their own burden to hold. It should be societies as a whole, and especially for us as individuals who are working to protect those. We ask you to call on the Nebraska Attorney General Mike Helgers and the Iowa Attorney General Brenna Bird to immediately withdraw from Texas versus Kennedy lawsuit. Again, it was Texas v. Becerra, and now it is Texas versus Kennedy. That all 17 state attorneys generals involved drop their support of Texas v. Kennedy lawsuit. So it's not just our two states, but the entirety of them, especially because, as Elizabeth mentioned, it's moot on two points. And that our community here in Nebraska and in Iowa, that we stay alert, that we share details as soon as public comment periods open. The Department of Energy is proposing rollbacks of accessibility requirements under Section 504, etc. If there continue to be other attacks, we want to make sure that we are prepared and that we have the information to be able to comment as to those. So thank you. And I will turn it back over to Wendy.